Welcome and thank you for joining us today as we explore a critical issue affecting relationships: financial abuse and coercive control. Financial abuse is real, and it's often a hidden form of control, which tend to be overlooked, yet it's deeply harmful in its effects. So today, we aim to highlight the warning signs and share tools to help individuals regain their life and take control of their finances. We have a panel here of trusted professionals, professionals in law, investigation, and finance, and we're raising awareness about financial abuse and coercive control. We're here to create a safe space for you and provide guidance through the educational seminar to help you make informed decisions. Financial abuse is about power and control, when one person holds financial power and uses that to dominate another. Understanding this dynamic is very important about financial abuse and coercive control. It's essential, especially during marriage or divorce proceedings. This knowledge is crucial in ensuring financial independence as you move forward. Financial abuse happens when one partner controls all the financial resources, disrupts the balance of power in the relationships. When confronted, this behavior tends to escalate. And financial abuse is not only behavior that happens in the relationship, that often is tied to a coercive control and other forms of domestic abuse and violence. So join us as we dive deeper into these critical issues today. Financial abuse can be hard to recognize, but it has many faces. It can include restricting access to money, monitoring every purchase, sabotaging employment opportunities, and forcing someone into debt and ruining their credit. Often it starts sadly, but escalates, trapping individuals in a cycle of dependency and control. No one should live under these type of circumstances. Financial abuse creates a web of dependency. It makes it difficult for a victim to leave. Essentially, you feel trapped. Without financial resources, the idea of escaping becomes pretty much impossible. This abuse can lead to long-term damage to your credit, employment opportunities, and even legal outcomes, making your recovery a long journey. Financial abuse can continue after the divorce is finalized. It's not over, and you should be prepared and be vigilant as you move forward. Some abusers refuse to pay court orders support, and they sabotage financial recovery and destroy one's credit, even harass their ex through illegal fees. It's crucial to stay vigilant and continue pursuing legal action to enforce financial settlement or restraining orders if that's necessary. Financial abuse is often a part of larger pattern of coercive control. These abusive tactics attack personal freedom and self-esteem, using intimidation and isolation and often other intimidating tactics. Outsiders might not notice these signs. It looks like it's a perfect couple from the outside, but the impact inside of the marriage or relationship could be devastating. With that said, I'm going to pass to Jason, who is a criminal defense attorney, and he's going to take this with the legal aspects of coercive control and take a deeper dive of that.
Thank you, Tatiana. Well, when we're talking about coercive control, it's basically based on a sort of a very general premise that the abuser holds, and that is to create a situation where his or her spouse or partner feels as though they can't survive without you. And this is found quite often in the financial field for many of the things that Tatiana just discussed. So when we talk about coercive control, just by way of examples that are very common in the domestic violence realm, is usually starts with the monitoring and control of communications, you know, checking your cell phone, having your passwords, things of that nature. Monitoring, controlling your movements, wants to know where you are at all times. You know, maybe demands that you have some sort of GPS locator on you, or in some cases, plants a GPS locator that you're unaware of. A very common thing is to isolate the abused person from friends and family. If that person's loved ones don't know what's going on, they can't help her, and that helps that abuser maintain control. And a big thing is also to basically deprive basic necessities, to demand compliance in order for providing basic needs. So basically, it really is just about a total financial dependence. So, but what I think is important for people to note is that the law with regard to domestic violence in New Jersey has recently been changed. Interestingly enough, though, it's really just put into code stuff we already usually talked about in domestic violence trials, things that already existed. But it was part and parcel of a large domestic violence package that the governor of New Jersey signed into law in January of this year. There were four basic domestic violence bills that Governor Murphy signed into law. They dealt with the use of foreign language forms. Up till now, they were foreign language, domestic violence forms were only in English. There was a law that added for the protection of unborn children for pregnant victims, which is a nice, interesting change. A requirement that law enforcement now provide domestic violence victims with records upon request, which is important because domestic violence trials happen very quickly after a domestic violence accusation. And the fourth law that was passed is what we're here to talk about, and that's that of coercive control. So the question now is, how is that going to affect domestic violence hearings? Well, quite basically, it just really establishes another avenue of establishing domestic violence. You know, you have your basic predicate acts that usually revolve around assault or harassment, terroristic threats, things of that nature. But now coercive control is going not only to be considered by the court, going to be required to be part of the court's decision-making process. And so for your legal practitioner like myself, what are we looking at as ways to try to prove that this coercive control is going on? In this day and age, we're usually starting and ending with text messages, emails, things of that nature. People are usually too quick to put things in writing. When we're talking about the financial aspects of coercive control, obviously we're going to be looking at bank statements. This is where you might have to get Tony involved, because then you're going to want to look at some forensic accounting if things are getting really complicated. And as usual, in any domestic violence trial, it's going to come down to witness testimony. Friends, family, coworkers, right? Have they been privy to the coercive control of the abuser over the victim? And can they testify to things that they've seen firsthand? And then obviously, maybe most important, is you're going to have the testimony of the victim herself. More often than not in a domestic violence trial, if someone's covering their tracks, if they're not as willing to put things in writing by text and emails, if they've been careful with the way they handle the finances coercively, it's really just going to come down to the victim's testimony versus that of the alleged abuser. And that's usually of paramount importance in a domestic violence trial, and it will remain even when testifying about coercive control. The good news for victims of domestic violence who are going to be claiming coercive control is some of the remedies that are available to these individuals, both in initially gaining the temporary restraining order and then hopefully having that converted to a final restraining order, is the court can't order either interim relief or permanent relief that's going to sort of stem the tide of the coercive control aspects. For example, giving the victim possession of a residence. Now, if the abuser was denying basic necessities, one of them is shelter. And if a judge orders that the victim gets to possess the residence, obviously it's no longer in the power of the abuser to deny one of those basic necessities. Other examples are a judge can order, status quo, what we call status quo with regard to how the bills are paid, financial support on a pendente lite basis. And the judge can order things related to sort of undermining and reversing this financial control. He can order the alleged abuser to cooperate with regard to divulging information on accounts that previously the alleged abused victim would not have had access to. And there is an element of financial relief that, if given, would allow victims to open their own bank accounts and start to get back some of that financial freedom that they lost at the hands of their abuser.
All right, so now we're going to do a little bit on a case study, and we want to show you how these examples demonstrate coercive control and abuse in a real life scenario. So here we have a Sarah and Tom couple. Sarah's 45, Tom 47. They have 2 children. They're married 20 years. Sarah, stay-at-home mom, has no access to family finances. He managed all her finances. Tom managed all finances and restricted Sarah's access to financial information. And when Sarah tried to inquire in that, she usually got, "It's okay, I know what I'm doing and I got this." And Tom also had a lot of it done electronically, so she's never been exposed to any type of paperwork behind it, any type of statements. Sarah had 1 credit card with a strict spending limit, and she received an allowance, which was very strict, and she could not go over it. Sarah had no financial knowledge of her family finances. She had no understanding of that. And as I said, everything was paid electronically by Tom. 18 years ago, they agreed that Sarah is going to stay home and raise their 2 children. So current financial situations, Tom incurred over $200,000 in debt in Sarah's name without knowledge of Sarah, and he hid some marital assets in a secret account. The relationship deteriorated over time, with Tom becoming verbally abusive. And Sarah finally got courage to stand up for herself and decided to get out of this abusive relationship and file for divorce. She was worried about her lack of knowledge regarding their assets and liabilities as their marriage started to unravel. So she filed for divorce, and during the process, they uncovered that hidden debt and assets in the marriage. So I'm going to pass this on to Jason, and I'd like you to speak of the focus of this case and the strategy that you could implement for the victim.
Well, Tatiana, above and beyond sort of the maybe seeking a temporary restraining order, which would allow for some of that temporary relief that we had just discussed, there are some criminal aspects of what it is Tom is doing here that include things like identity theft and fraud. And that's something you're going to want to pursue. And that would be something I would help shepherd Sarah with law enforcement. And she's a victim of a crime here. So she's definitely going to want to cooperate with regard to that. And I think this case is ripe for a temporary restraining order. And there would, I'm sure, in a situation like this, be some other things that are more what we would consider sort of traditional domestic violence things. If Tom is this type of abusive spouse, that we would certainly explore in order to get Tom to be under the auspices of a temporary restraining order, and B, keep Sarah safe while this is pending, and then turn it over to Paulina to do what it is she does.
So Paulina, tell us about your scope of, shed some light on this, and what would be your strategy in this case, please?
Sure, of course. So first, I'm a matrimonial attorney at Ziegler Law Group. I work alongside with my partner, Jason LaBeouf, who spearheads our criminal defense practice and domestic violence practice. Together, we work in tandem along with experts, both forensic and otherwise, to work in achieving the best results for our clients who find themselves in situations similar to Sarah's and Tom's, and help them get to a better and brighter tomorrow. So look, financial abuse and what Sarah is experiencing, it happens slowly over time, just like Sarah has experienced in her case. It doesn't start from the day the filing starts. It's a buildup. There's usually signs of such abuse typically that occur during the marriage. So I think first and foremost, it's really important for people to look for the signs of financial abuse. Look for those signs leading up, or look for those signs during the marriage or during the relationship, and look for them in the litigation process as well, so you have a better understanding what you're facing, so you can seek resources, seek the advice of counsel, whether it be for a restraining order or whether it be for matrimonial dissolution proceedings. So ask yourself the questions. Do you, like Sarah, lack access to your bank accounts? Do you lack access to your credit cards? Do you have a spending limit on a credit card for statements that you do not see on a monthly basis? Have you been discouraged from finding a job or forced to quit one? Have you been forced to sell assets against your will? Have you or have assets been sold without your knowledge and consent? Are you on allowance? Has money been taken away from you? These are all relevant questions for you to ask yourself during the course of the relationship and during the litigation proceeding, so you can say, you know what? This is happening to me. Sarah is now clued in that this is what's happening to her. She's in the midst of this, and she's acknowledging that there are steps that I can take that will protect me. So abuse doesn't usually start just during the divorce process. It starts during the marriage, and then it continue into the divorce process. So during the divorce process, there are tactics that are taken frequently. Tactics will be to file a motion to sell assets prematurely before those assets have been valued, or file a motion to gain leverage to try to get a financially dependent spouse excluded from the residence or out of the marital residence. Hiding assets. That's always a popular one that happens during the divorce process. Ruining someone's credit is something that also is a form of financial abuse that happens during the divorce process. So be mindful of it, make note of it, seek the advice of attorneys, and then advise your attorney of what is happening, what you're seeing around you. What can we do as attorneys? What can we do to uncover hidden income or underreporting or underreported income? What can we do in situations when there's undervalued business assets or transfer of assets to third parties? The first thing that we can do, of course, is discovery. It's the biggest tool. Discovery can take numerous forms. It can take the form of written questions served to the other side that are interrogatories. It can be for the request for document production from the other side, or we can go directly to the source. We have subpoena powers. We can serve subpoenas on financial institutions, and we can get the documents directly from the sources. One may ask, what if there's hidden assets and you don't know which financial institutions to target? that's when we would work with someone like Tony, and Tony will talk more about what he does. But that is the collaborative approach where someone like Tony, we would task that expert with doing what's called an asset search. And Tony will talk all about that and how we can go about uncovering assets that you may not know about. It is solely titled in one spouse's name. It's not titled in your name, and you're unable to cover that. Some assets that are not in your name are publicly available, and there are things that we can do first to provide at least Tony with a starting point of where to go. There are certain things that we can do on our own in terms of searching public records to be able to give Tony a good amount of information to at least have a jumping off point. We can also conduct depositions, which is sworn testimony where we ask the other side various questions, and that's not limited to just the other spouse. We can also depose potential third-party witnesses that may have other knowledge, partners in business and the like, for an example. So discovery is an important tool. It is a tool that is very important to utilize an attorney that is knowledgeable in this area that can set you up not only with the right team, but can really be the spearhead in the discovery process to make sure that you are getting to the right information and you're finding the correct information. What else can we do? Well, we can hire a forensic accountant. A forensic accountant would be able to analyze the financial records that we would be able to obtain with Tony's help. A forensic accountant will be able to do things like a lifestyle analysis to be able to better ascertain somebody's cash flow or the cash flow that the parties had available to them for their marital lifestyle. A forensic accountant can do valuation of a business and the like. A forensic accountant can do a tracing analysis of monies that are moved between accounts or in and out of accounts. There are numerous things that a forensic accountant can assist us with. We can use Tatiana's services. Tatiana could potentially look into the way that the accounts or assets were invested during the marriage and give advice with respect to that. The important thing is that you have to be able to identify what's happening, and then once you've identified what's happening, be able to communicate that to a team of trusted professionals in order to lead you to get the results that you deserve. So let's talk about some things in the divorce process that you can do that will assist you in the divorce process to combat the fraud aside from the discovery process. If you, like Sarah, have assets that are solely titled in the spouse's name, you can be rest assured that title does not matter for the purposes of equitable distribution. What the court looks to is not how the asset is necessarily titled, but when the asset was acquired, the source of acquisition of that asset. So for example, if a home that was the marital home was acquired during the marriage, but it was acquired solely in the husband's name or the other spouse's name, that does not necessarily mean that that marital home is not subject to equitable distribution. Something to look out for with situations of financial abuse during the marriage is the misleading of a spouse to believe that they are not entitled to certain assets. If a spouse is being put into a financial stranglehold during the litigation process, we can file a motion for pendente lite support. Pendente lite is a term for interim. It literally means during the pendency of the action, and it is support to be able to allow a spouse, and the less moneyed spouse, to be able to get through the discovery process and to trial. That is the purpose of pendente lite support. So you're not cut off from access to your funds. What do we do in situations when Sarah does not have money, and she's concerned that she's not going to have the financial wherewithal to hire the experts. The experts are and that's something that needs to be taken into consideration. So what do we do in that situation? We would file a motion with the court to ask for a litigation fund. We would point out that Sarah is the lesser moneyed spouse. She has been a stay-at-home mother for the better part of 18 years. It would be very difficult for her to come back and secure employment, certainly employment that's commensurate with that of her husband in this situation. And as a result, we would ask for a litigation fund so that Sarah has money to be able to hire experts and counsel to help her through the divorce process. Those are just some of the ways in which we can combat the financial abuse that can occur during the pendency of the divorce litigation.
Lena, does presence of financial abuse impact the equitable distribution during, post-marriage?
Certainly. So the concept of equitable distribution in the state of New Jersey is the identification of assets that were acquired during the marriage and the distribution. Equitable does not necessarily mean equal, and there are a series of factors that the courts take into consideration when distributing assets. Fairness, the family court is a court of equity. Fairness is a guiding principle. So fairness includes the analysis of all of the financial circumstances of the spouse. It then includes the court would then look to the contributions that each spouse may have made during the marriage to the acquisition of the various assets. It may look into whether the supporting spouse pursued a career, or in the alternative stopped pursuing a career in furtherance of the marriage. So there are a number of different things, and the court can also consider a spouse's potential bad faith in the analysis of equitable distribution. Certainly in extreme cases where we have potential marital waste, where assets are being undersold, or where it is not an arm's length transaction. If one spouse without the other spouse's knowledge sells an asset to a friend for an undervalued price, that there are ways for us to combat that. There are ways for us to show proofs to the court that would demonstrate that. And that is something that the court would then take into consideration. Certainly, if an asset, for example, was sold in not an arm's length transaction, but was sold to a buddy for a wink, wink, nod, nod price of, let's just use round numbers, of $1,000, when the value is really $10,000, that is the way that we can utilize Tony or other experts to be able to assess what the value of that asset was and show the court that, in fact, marital waste occurred here by this, aside from the fact that it wasn't an arm's length transaction, but certainly marital waste has occurred here because the value was devalued. Other ways, of course, is trashing an asset or intentionally not doing work, or, with marital residences or other real estate, we have the lack of upkeep where the price is being driven down artificially. So yes, those are all ways that the court can consider the financial abuse and its impact in equitable distribution in the divorce.
Okay, thank you. Jason, I understand when a lot of this coercive control litigation happens, it often depletes a marital assets because the fees have to be paid somewhere, and they usually come from those assets that are at that time marital. Does that change at all the distribution of fees if the one party is clearly at fault at the end of the distribution of the assets?
Well, from an equitable distribution standpoint, that's the stuff that Paulina just touched on. From a domestic violence standpoint, one of the remedies for the successful plaintiff in garnering a final restraining order is the payment of attorney fees.
Thank you. So, Tony, if you can shed some light of how do you work with professionals assist them to uncover all this domestic abuse and hidden assets, and give us some examples. You can go beyond the scope of this case as well.
So I'm Tony DiLorenzo. I started 50 years ago in this business. It's a national company. So if someone lives in New Jersey or works in New Jersey and they work in New York or they work in Pennsylvania or they work in Texas, I could pull all the data on a national level. So it doesn't mean that you have to hire someone else. What we find out is that a lot of guys who are going to go for divorce, they plan this well in advance, 1 year, 2 years, 3 years in advance, because they know they're going to go for a divorce. So some of the things we start with is that to find assets, I do a background check. It shows me all cars owned, boats, planes, anything that vehicles that they own. It tells you when they bought them, when they sold them, because all of a sudden, if a guy has a car and now it's disappeared, it might be in someone else's name. Other things that we do is that I could get all my information is used for discovery. I get discovery and it's turned over to the attorneys for use. I could pull someone's credit card bills for 12 months of all their charges. I could also find credit cards that they don't even know about. So what happens, we find these credit cards and the guy always says, I'm broke, I have no money, I can't pay you. Here he is taking vacation she don't know about. He said he was working. We can show that dinners are for 2 people at a time, which means it could be a girlfriend or someone out he's spending the money on. So we could track his lifestyle down. And again, in depositions, the attorneys could ask where all these charges are for, which shows some of his assets. I could also do bank accounts where I need his name, last known address. If you don't have the date of birth, I could get it. If you don't have the social number, I could get it. We scanned upon the top 25 banks in the country, and what it does, it tells us John Doe has an open account at Chase Bank. It was open on so-and-so date, and the current balance as of today is X amount. And then we can find if it has any safety deposit boxes, because a lot of times a person who might be cashing checks or in a cash business, they're bringing the checks right to a safety deposit box, not known. But that's a good thing for us, for attorneys to try to lean, so we can find out actually what's going on in there. Also, what we do is that I can do stocks and bonds, the same exact thing. Now, people who come to me a lot of times are in the cash business. The wife says, my husband ran all the things. I don't know who the partners are. I don't really know what business they are. He has businesses in different people's names, so it won't come back to him. So I do surveillance and we follow him. Say the person owned the deli. And he said, I only own one deli and it's doing really bad. But when we follow the person, say over a week or so, we have him stopping at 3 or 4 different delis. But the difference is that we'll go into the deli. He's behind the counter. He's giving instructions to people. So he's not someone going for coffee. He's someone who we believe might own it. Then when we do surveillance, we see who he meets, what contacts does he have. So if he has a luncheon with someone, we could time that person to another deli. That could be his partner. We also, when we do surveillance, we find out what we can follow and see what banks he goes to. So say he goes to a bank and we did a bank check on that bank and there's no accounts for him. There's something in that bank, the reason why he's going to that bank. So again, we could time into a partner or who he's meeting. Other things that we do is if a person has a girlfriend, he's saying, well, I'm going to leave my wife. I'll end up, with my girlfriend. Here, we did a job where the guy, they finally got divorced. He was in his 50s. His girlfriend was like 30 years old. 2 weeks later, the girlfriend buys a condo for $400,000 cash. So we went back and showed her income that there's no way in the world because she could ever afford a $400,000 deposit. So that brought it back to the attorney saying, well, where did that money come? Because now you're living with your girlfriend. So you're never going to find all the money, but we can find a lot of the money to give him a chance to really start strapping down where his funds are. And I said, another thing we could do is that a lot of people keep all the information on the computer and they delete it. But I have a contact, an agent of mine that we could go into the house, it's community property, and we could download that computer, every email possibly that's on the email. And we break it down, finances, money, properties, travel. I love you, I miss you. And all these words go in different categories. And everything that they deleted appears. So we can find emails that she doesn't know about. We might find events or things or business decisions that he's doing on the computer. and we give you a full detailed report. And again, we turn everything over to the attorneys, and they could do it in depositions. Because once you get in deposition, you have all that information that you need. It's easy to start, building off the questions because you already know the answers. So a lot of stuff there is what we do. Also in the cash business, say a guy owns an auto body shop. I got 5 days, business is bad. Okay. So what we would do is we put surveillance on the auto body shop. We want to find the workers who are working there because more likely they're getting paid off the books. So now I have all the people's names. I find out where they live. And then we're document every car going in. We document the license plates, the type of car going in now, say for a week or two. Then what we would do is actually send my agent into the place and say, I need an oil change. I need like a minor little thing. How do you get paid? Oh, we only accept cash here. So say the bill is $150, we give them $150. We actually have the service done, and to give them $150, we say, well, I need a receipt. And the guy would sign $150 paid in full for the thing. So now we're just locking up more that when you go into court, that here's a procedure of how he handles all his cash businesses. And again, who the people he's meeting, what locations he's going to. So what I'm doing is I'm a fact finder. Attorneys will say, here's something we want to focus on. Here's something I need to know. Here's something I want to dig into. And I work with that. I work mainly with the attorneys and then also work along with the clients.
Thank you, Tony. Are there any of you have experience with offshore accounts? And if there is any chance that you can trace that?
So how you find offshore accounts in certain countries, only certain countries guarantee money in the bank. Like the United States, we have where all your banks, all your money is funded. So we know that in certain states, only maybe 4 banks or 6 banks of America, where all American people put the money in. So we can scan those banks the same different way. Say someone who's very common, we have clients who send money to India all the time. So what we do is that we'll find his bank accounts. He has 2 bank accounts. Then what we would do is that we scan 12 months back on his things, and it would show wire transfer, and it would show exactly what country. Sometimes, most times, we'll have the account number. And depends what country it is, we can take that account number and find out who's receiving that kind of money. It might be his mother, his brother, sister, and that's where he's funneling money that a lot of clients would never even know about.
And Paulina, you want to elaborate? What do you do with all that data? Sort of, what can you do?
Well, that this goes back to finding the right team and having your attorney be able to work with the right type of expert to get you the best results. So it's difficult. It's not easy, as Tony pointed out, to find foreign assets. Not every single country is receptive to foreign subpoenas or is even willing to give up information. Certainly, one way to find that out is on the domestic side, is to find the source of the money, right? So you have that forensic account, or you have someone like Tony who's going to be able to identify the account from which all the money is leaving. You see the transfers, you see the withdrawals, but then you don't see the corresponding landing place, or you do, but you recognize that it is a foreign institution. There are certain countries that will honor a foreign subpoena. There are certain countries that there are processes, even local processes, that you can take that will then at least give you access to those banks, but that's not every single country. I think that the best approach, of course, in those situations is to identify the money leaving the account, do your best to identify the foreign bank or someone overseas to whom the money is then leaving, and then utilize that information during deposition or potentially cross-examination to further delve into the topic and get more information as to where the money is going and who the money is going to.
And
is there
a statute of limitations how far you can go in looking for these transactions, or there is not? Paulina.
Well, I guess it depends on how remote the potential transaction is. So if you are in the midst of a divorce and you are seeing right prior to the commencement of the divorce action, a lot of money being funneled out of marital accounts or accounts that are subject to equitable distribution, then that would be certainly relevant for the court, and maybe an argument would be made for divorce planning on the side on the side of the other spouse who's doing all the funneling of the money. If you are looking into transactions that are very remote, it would be more difficult to establish that there is a way by which to make a recovery for you for the assets. And when we say remote, usually aside from a proofs issue, banks, for example, usually keep bank account records anywhere between 5, 7, an absolute maximum that I've seen about 10 years. So if you're talking about something more remote than that, you have an issue of proofs, of course, and that's something that you need to consider when pursuing these arguments.
Okay. Yes, Tony, you want to add something?
So one thing is, going back to the cash business, is what we like is that when we do surveillance on someone and we start finding out they have people that are paying off the books, or people who are not legal, or people that they're meeting with that really don't want to be known. These people don't want to get dragged into a court. So sometimes they put the pressure on the person that we're investigating to just settle, because they don't be brought in. They don't want the IRS coming in saying, I have all these employees and they're not legal and I'm paying them cash. They might be doing cash deals with other type of people that are also in the cash world, that they don't want to be brought in by court and saying, because they don't want to open a can of worm on those people. So we find a lot of times if you catch them, not every day, if you catch them with the right person, that's going to put the pressure on. So listen, you better just settle this, because there's no way we want the cops or anyone involved that we're dealing cash bring us in. And sometimes that gives a lot of power to the client to try to get a settlement. You're never going to get all the money, but you get more than probably what they're going to offer.
In the divorce context, what Tony is referring to is a case by the name of Sheridan. Judges in the state of New Jersey in matrimonial actions are mandatory reporters for issues dealing with defrauding the IRS, underreporting of income, and the like. So if you are raising this as an issue, especially with the kind of credible proof that we're talking about in this situation, in cash businesses, assuming that there is an underreporting of that cash on tax returns and the like, that often is a way that we can suggest that a case is better resolved through other means, such as alternative dispute resolution means, such as mediation or arbitration, outside of the court, outside of the sworn testimony that a party would have to give on that issue if they were to continue going through a court proceeding. And I think this is also somewhere where in the case of Sarah and Tom, Jason mentioned briefly about the other potentially criminal violations, and that's something that Jason can also assist, although we will never threaten criminal prosecution in a matter, but certainly these are all areas that should be discussed as terms of what's the best way to proceed in the action.
And then Jason, having the restraining order in place, how does that impact the alternative resolution, like mediation, arbitration?
Well, it could be a little bit of an obstacle. If there's a restraining order, you're not supposed to be in the room together, not supposed to talk to each other. We have figured out ways around that, but it can be an obstacle.
Thank you. Is there anybody else like to add to Sarah and Tom's situation? Or we can close this.
I think we're all good.
Okay. Well, now I guess this is where I pick up the pieces. I'm Tatiana Sunik. I'm a wealth advisor and I'm a certified financial planner. And I went through my own divorce 10 years ago, and I want to take a deeper dive into financials of a divorce. And I got my CDFA. This is where I would work with Sarah during the process. I would start working with Sarah during the process of divorce to make sure that whatever we're contemplating in that equitable split makes sense for Sarah and is going to serve her well, with her 2 children. If there is something in terms of taking more assets or alimony or making it more, in child support, we're going to go through all these numbers together. The most important thing to tackle would be her credit history. Obviously, that's going to take time to rebuild, but we can take steps and try to see if we can, over time, rebuild that credit history by taking small increments of debt and paying them off over time. Also, her fraudulent debt, that hopefully that would be disputed and dismissed, and she's not going to have to be liable for that, because that would be an issue. And then we will work on establishing her personal finances. If there is enough wealth between Sarah and Tom, how are the kids going to be taken care of in terms of their education, expenses like that? I'm also gonna do a full scenario to see if Sarah should really keep that home or should it be sold. What would be a realistic scenario in her life going forward? A lot of times these type of litigations can create quite a bit of debt and fees. So, whatever these couples walk away after that could be significantly reduced. So we have to make sure that we set realistic expectations. That's when I'm going to be working with Sarah to help her create that financial independence long-term plan, which is going to be one step at a time. I strongly suggest people in this position don't rush into anything. Educate yourself, work with your financial advisor, and take your time. Work with the mental health professionals. There's definitely abuse sometimes clouds that decision making, and you do need sometimes professionals to lead you to see that light at the end of a tunnel. There is that next chapter. It could be wonderful, but there's some healing to be done. And also, setting guardrails around the financials to make sure we're going to assess Sarah's current education and her ability to make living and earn. And if there's some kind of schooling that needs to be done, perhaps that could be discussed in the divorce and can be financed by another spouse. And she can go back to school, get some degree to support herself and the children. And over time, we're going to see how that would look like to build her up, create that financial independence, so she has ability to retire at some point in life. Some retirement assets would be split. Some of that she's going to get through quadros. Some we will roll over, some we might keep in quadros. Also, I would say it's important to also understand that Social Security, if Sarah never worked, she is by law allowed to have some portion of Social Security from the spouse, and that cannot be waived through a divorce. Then the question comes, if Sarah wants to remarry, how does that play? But we'll cross that bridge when we get there. But there are a lot of aspects around financial planning, and that would be mostly budgeting, setting a realistic expectations, saving, because if the spouse gets alimony during her life, that is very important to keep in mind. That money is going to stop at some point, and that should be invested pretty conservatively, given that that might be the only income that the spouse can have. And that could be used for her financial independency and retirement in the later years. Also, part of it will be child support to make sure kids are set. And hopefully she can go back to work and earn some income. And then house, realistically, what was the upkeep of house? It could be all analyzed and see if it makes sense to keep the house. And there are also various ways to buy out the spouse from the house, if someone would like to keep a home as a personal residence. So all these steps, we can dive deeper. I'm just kind of scratching this on surface and giving you some examples. So basically, from the outcome of this case, with the help of professionals, we work together to uncover these hidden accounts and divert marital funds. And Polina will secure appropriate share of the marital assets for Sarah and find relief from the fraudulent debt. And Jason will, take the necessary steps to bring charges against identity theft and fraud against Tom. And I will work with Sarah to help her rebuild her credit and dispute her debt and establish that financial independence. So that's in a nutshell, just kind of summary of the case and in the theory in real life, how that would play out. So thank you so much for being here today. Financial abuse is definitely tough, but by learning about it, you're already taking steps to take back that control of your financial future. I strongly encourage you to be vigilant, and recovery is a process, but remember, you're not alone, and there is a support out there, and there's trusted professionals that can help you and guide you through this. We are building a trusted community of matrimonial professionals. Feel free to reach out if you have any questions and join our upcoming workshops for more help. Take care and thank you again for your time. Bye-bye.